Feels so long since we've seen each other. I'm going to call to order the 86th meeting of the Standing Committee on Citizenship and Immigration as we continue our study on the federal government's policies and guidelines related to medical and admissibility of immigrants. We thank the minister and officials for joining us. We're partway through the study. We've had some officials here before. As we opened our study, we've heard witness testimony over the last 2 days, and we're delighted to be able to have the minister here for his thoughts as well as the help from the officials. So thank you for agreeing to come to see us today. And it's over to Minister Hussain.
Thank you, Mr. Chair. Thank you to members. It's always good to be back before the committee to share with you our perspectives. Merci, Monsieur le Président. Je suis.
Thank you, Mr. Chair. It's a pleasure to appear once again before this committee. The government appreciates the committee's decision to undertake this study.
Immigration, Refugees and Citizenship Canada has undertaken a fundamental review of the excessive demand provision, and we've consulted with the provincial and territorial governments. And as I have openly stated to my provincial and territorial counterparts, this review is necessary and long overdue. Just to put it into perspective, this provision has been in place for more than 40 years. From a principled perspective, the current excessive demand provision policy simply does not align with our country's values on the inclusion of persons with disabilities in Canadian society. The current objective of the provision is to strike a balance between protecting publicly funded health and social services and facilitating immigration to Canada, while also supporting humanitarian and compassionate objectives in Canada's immigration policy. But there is now a recognized need to realign the policy to also make it more fair and inclusive of persons with disabilities. And as you know, Mr. Chair, to begin our review of this policy, our government launched consultations with provinces and territories in October 2016. Departmental officials also engaged stakeholders, including disability advocates. The results of these discussions, together with consideration of public perspectives, judicial decisions, media reports, as well as this committee's recommendations, will inform the development of options to be presented for decision by the government. As my officials indicated previously to this committee, the health inadmissibility provisions are designed in part to reduce impacts on Canada's publicly funded health and social service systems. While a number of policy principles underpin our review of the excessive demand provision, this includes the need to continue to protect health and social services. Ceci étant dit,
that being said, the numbers we are talking about are incredibly small.
Benefit analysis found that the total number of decisions on excessive demand made in a single year will result in an estimated savings of about $135 million over a period of 5 years of projected healthcare coverage. That amount represents just 0.1% of all provincial and territorial health spending in 2015. Since our initial discussions, we have shared potential areas of change with provinces and territories. These have included possible adjustments to the cost threshold, changes in the groups exempted from the provision, redefining the services under consideration, or enhancements in how wait lists are considered.
This information will give provinces and territories the opportunity to assess these options and the potential impacts on their jurisdictions.
Our federal, provincial, and territorial meeting of ministers responsible for immigration, we are committed to ensuring that the policy continues to recognize the need to protect health and social services and education while treating applicants fairly. In particular, our government wants to ensure that the implementation of this policy aligns with our values regarding the inclusion of persons with disabilities into Canadian society. Once again, I appreciate that the committee has chosen to undertake a study of this really important and sensitive policy. Le gouvernement est impatient de...
The government looks forward to receiving the committee's recommendations Thank you very much. It will be my pleasure to answer your questions.
Thank you very much, Minister, and even thank you for your brevity to give our committee lots of time to ask questions of you. On va commencer avec Monsieur Taber.
We'll begin with Mr. Tabera from the Liberals.
Minister, for being here today. Minister, we've had, in this study, we've had individuals come here and share their testimony. One individual was a caregiver. Another individual was a professor at university. And in both cases, they have lived in Canada, paid their fair share of taxes. They felt like they were good enough to work here, but they weren't good enough to stay. And it was hard to hear some of their testimonies because they felt like Canada is not welcoming and it's splitting their family. From ongoing testimony, we felt that there was a two-tiered system, and I was just wondering if you can just elaborate on that and how we can be more welcoming and how we can kind of strike a balance between allowing these individuals to be here with their families because they've contributed so much, and striking a balance with healthcare providers as well.
Thank you. That's a really important question. The issue around, before I answer the question, I just wanted to say that one of the reasons why in Canada we have an excellent settlement and integration program that is the envy of the world is not just because of the government's efforts. It's also because we have a very welcoming society, and Canadians are open to welcoming and embracing newcomers. And I think that the reason why you hear these cases and they come, the cases that we know about and the ones that don't make it into the media raise issues around fairness, and this is precisely why we've decided to launch a fundamental review of this policy, and why we are making sure that we hear from everyone on how best to move forward with the underlying reasons for the policy, but also bringing it into the 21st century, making sure that the policy, that the excessive demand policy, aligns well with our with what Canadians expect in terms of the inclusion of everyone into Canadian society, and that is why I'm very eager to get the recommendations and the feedback from this committee on ways to move forward on this. The cases you highlight do raise issues around fairness, and this is precisely why we need to review this policy to make sure that it's in line with Canadian values. The final point I'll say about this is this policy has been in place for more than 40 years. We're doing something that no other government has attempted to do, which is look back and say, okay, how can we bring this policy up to Canadian values on how we include people. So we're doing the right thing. It's just making sure that we do it right, and to get it right, we have to hear from the committee as well as provinces and territories that are impacted by any possible changes to this policy.
I just want you to elaborate a little bit on fairness. I don't think this review is looking at family as a unit. And I just want to ask you that is, when we do look at this review and we're looking at policy changes, are we going to be looking at family as a unit and their contributions to the greater Canadian society?
So I think, first of all, that the committee is open to looking at this policy from their own perspective and coming up with their own recommendations, and I'm certainly open to that. And secondly, I want to reassure you and the committee that all options are on the table with respect to moving forward on this policy. So you have my word on that. And so if that is something that you think we should do in terms of having a more comprehensive look at the contributions of family, that is something that you can certainly put forward. The only contribution I'll make to that suggestion is that Australia has moved forward on that approach, and they weren't able to succeed. They weren't able to succeed in terms of looking holistically at families.
The second question I wanted to ask is under humanitarian compassionate grounds, a lot of testimony was provided, and we heard that this avenue was very difficult for individuals to be approved. One of their family members may have been inadmissible to Canada, and then their next option was to apply for humanitarian compassionate grounds. Some were successful, but very many others weren't. If you can elaborate on that.
Okay, I'll let my official answer that question.
So in the material that we presented to the committee, Mr. Chair, under the undertakings from our last appearance, undertaking specifically number 15, we provided statistics to the committee that looked at immigration medical exams from the year 2013 to 2016. And 224 people applied for humanitarian and compassionate consideration, and 91% of them were successful.
Okay, then never mind then. My final question will be if you can update the committee on the department's ongoing work with provincial and territorial counterparts on medical disability. During all these testimonies, we heard a limited amount of testimony on provinces and territories.
So before I let my official respond in detail to the question, I will say that the consultations with provinces and territories has been ongoing. I met ministers responsible for immigration at a federal, provincial, territorial meeting in Toronto, and this was top of our agenda. We had an in-depth discussion on how to move forward on this, and there was a variety of opinion around the table. They were very supportive. Provinces and territories are very supportive of the review. They think we should look at this again. They're a little apprehensive, some provinces, about the costs that they think they'll have to incur, but they do agree with the general premise that we need to bring this provision in line with our other accepted policies with respect to moving towards an inclusive approach towards people with disabilities.
Thank you. I'll let the official respond, and
I think
it's okay. Very good. Ms. Rempel.
Thank you, Mr. Chair. Well, Mr. I think for once we agree on something. Our immigration policy shouldn't be ableist, but it also needs to be cognizant of the need to ensure sustainability of our social programs. It's a balance in this situation. We've heard testimony from quite a few experts in the field who have made some suggestions on low-hanging fruit, as it would be in terms of ways to change the process. One of the things that came up yesterday was the fact that it's not so much the legislative framework around this issue, but how the rules are currently being applied. And we've heard, dozens of cases where the rules were applied either unevenly or improperly. So I'm just wondering, as part of the review, have you instructed your department at all to look at perhaps a new training mechanism or some sort of service delivery standard to ensure that department officials are actually following the law consistently and perhaps putting some more consistency frameworks in place to apply the rules in this situation?
That's a good question. No, I haven't done that because my position has been very clear from the beginning that we need to that this provision needs to be changed. It's simply not in line with our government's policies with respect to moving towards a more accessibility agenda, but also with Canadians and how they view how Canadians are increasingly of the opinion that we should be more inclusive as a society. So we just think, I personally think that this provision is out of date in terms of looking at those two things.
So are you suggesting then that where we would be going then is rather like that there would be no framework for this and that it would be removed entirely?
No, that's not what I'm suggesting. I'm suggesting bringing the policy in line with where Canadians are at today.
What does that mean?
It means being more inclusive and being more fair and addressing issues around fairness.
Like in terms of a legislative change, because you've just said that you're not looking at process change, and you're saying it's currently an issues with the legislative framework. So what legislative changes are you proposing?
We're not there. Look, the changes we will make depend on the feedback that we get from stakeholders, provinces, territories, and this committee.
Okay.
So we're not there yet.
Thank you. So one of the common denominator feedback that this committee has received is the application of the rules being inconsistently delivered in terms of your department. So being presumptive and assuming that there would be some sort of framework even after the results of your your review, what is your department doing to ensure that, because there seems to be a friction point with service delivery on this, and part of what immigration lawyers have told us, cases themselves have said that, like, we don't know what the criteria are. They're being applied unfairly. One of the comments was that essentially having to hire a lawyer if you here we go. We've heard that procedural fairness levels are difficult to understand and that most people want to challenge a finding of medical inadmissibility feel they must hire a lawyer. One of the recommendations that's come up many times is that your department could be simplifying the language in these letters. Like, what are some of the, regardless of what the legislative framework changes, it's clear that there's also a service delivery issue.
Okay.
So what is your department, have you instructed your department to look at those friction points at all?
I haven't instructed my department to do so. What I can update you on is that my officials have told me that there is, they are looking at process improvements in terms of how those decisions are made and how the applications are being processed. Secondly, they also welcome advice from this committee as we move forward. So that's where we are right now.
So then you would commit to undertaking a review of, because again, there's been, I think, a significant body of evidence in front of this committee already showing that part of the friction points or challenges in terms of the application of the framework has been service delivery points. Would you then commit to undertaking a review of that as part of the overall review that you're looking at in this framework?
So two things I'll say about that is, one of the things we're looking at is a centralized unit to make these decisions so that you can have consistency. The second thing is on overall, in terms of client service improvements.
So specifically so in terms of simplifying the language
so
in
a centralized unit to make consistent decisions with respect to these
medical
issues.
admissibility. Is there also being work undertaken to perhaps simplify the language that's coming out in terms of medical inadmissibility letters and the appeals process?
I can assure you that that's part of our overall client service improvement initiative. It's to improve how we communicate with clients, how they can track their applications, how they can get faster responses to their inquiries, and that'll be captured as part of.
Fantastic.
Yeah.
So just while I have you, because we rarely get a chance to chat, I just want to inform you and your officials that I have put the following motion on notice. I hope I don't have to move it. It's that the committee report to the House the matter of the failure of the Department of Immigration, Refugees, Citizenship Canada to provide the committee information it requested regarding the issue of asylum seekers on September 28, October 3rd, and October 5th, since privilege may be involved, and give the House an opportunity to reflect on this matter. It's been
Is that a question? Or?
I'm just informing you of the fact that this motion has been put on notice while your department officials here. I hope I don't have to move it. It's just been 2 months since the committee has asked for some of this information, and it's getting to the point where it's impacting our ability to look at other issues such as the supplementary estimates.
Okay.
Thank you.
You're welcome.
You have a minute.
Oh, one more question then. Fantastic. Just pushing on the issue of simplifying process, another issue that we heard was that the department is still sending out correspondences about medical inadmissibility by mail, and that sometimes medical certificates expired before a decision is even rendered. So I'm wondering if, as part of the review, your department is looking at perhaps delivering those notices via electronic communication or some way that can condense the timeline in terms of decisions, so that the time between getting that medical certificate and an actual decision rendered is condensed so that that decision doesn't expire.
Look, whichever way we can do client service better, we're looking at. Client service is at the heart of of everything that we do, and we should put the client at the center of everything that we do. And improving client services in my mandate letter, we have a department, a unit now in IRCC that is responsible for client service. We have a director general responsible for client service for the first time in the immigration department's history. It's a huge priority for me, and anything that can go towards improving client service, I'm open to, including on this issue. So if you think that we can, if you have specific suggestions such as the one you just articulated, I'm happy to and open to receive it, and it could be part of the recommendations from this committee.
Thank you, Minister. I just want to let the committee know, following up from Ms. Rample's comments, that, and the officials know that almost all the requests of IRCC have been submitted to the clerk already. They've not been distributed yet to the committee, but they're mostly in. They're all in.
No, they're not.
Not for, we're waiting from Global Affairs, CBSA.
So the ones that we are waiting for actually are not from your department. So they're from other departments that we may have to go after as well. But just to let you know that we have received from you, but we are still outstanding other information is outstanding, but it's from other departments.
Thank you for the clarification, Mr. Chair.
Ms. Kwan.
Thank you very much, Mr. Chair, and thank you to the Minister and his officials for agreeing to be here today. I want to start with this fundamental question. Minister, in your comments just now, you said, quote, provisions is out of date, referring to the excessive demand provision, and that you want to bring the policies to be more in line with a Canada that is to be inclusive of people with disabilities. We also have a variety of laws in place, namely the Charter of Freedoms in terms of our commitment to equality and human rights, our provincial and federal human rights legislation. As well, Canada is a signatory to the UN Convention on the Rights of People with Disabilities. Now, if you take a look at all of those rights in the context of the Immigration and Refugee Protection Act, you'll note that this provision is in fact contrary to those protected rights. So to that end, is the only option really in going forward is to do away with the provision of excessive demand. No matter how you tinker with the policy and its application, it is not going to align with those stated rights in our charter, in our human rights legislation, as well as the fact that Canada has signed on to the UN Declaration.
Your position is that...
No, I'm asking you of that question.
Well, I'm trying to understand your question. You're saying the only option that we should consider is getting rid of the
my question
policy?
to you is, would you agree that our only option is to get rid of the excessive demand provision, given that those rights and given that your stated goal?
This is how far I'll go on your question. I will say that all options are being considered, and that is one of the options. And I would say that all options are on the table.
Okay, so
but that would depend on where provinces and territories are the most affected by this provision. So we need to hear from them, but we also need to hear from other stakeholders which have appeared before this committee. And so we need to hear from the community, we need to hear from Canadians, and then we'll make the decision. But the only thing I can say to your question is that is one of the options, but it's not the only option.
Okay, so I can tell the minister this: the vast majority of the people who appear before this committee agree that the section excessive demand should be eliminated, should be repealed. I believe that there are at best two witnesses that appear before us who had put forward a list of actions that maybe can improve the current process. In addition to that, I can share with the minister that from my office I've received over 1,000 emails calling for the repeal of the excessive demand provision. And virtually everyone who appeared before this committee agreed that if Canada is to be consistent with the UN Declaration on the rights of persons with disability, then we cannot have a law that discriminates against people with disability. And how this discriminates is that virtue of the fact that you have a different ability, you have to undergo a different process. That in and of itself already creates a system of a two-tier system, if you will, and discriminates against people with disability. So I hope that the minister will take that into consideration. with that, and I hope that it's not just rhetoric to say that all options are on on the table for consideration, because this matters in terms of people's lives.
No, of course.
The minister talked about a cost-benefit analysis. In fact, from the officials, the benefit analysis side is actually missing with respect to this work. The witnesses all came forward to talk about their contributions from their family unit, but as well as the person who's been identified with a different ability in terms of their contributions as well. Some of it cannot be quantified in a dollar and cents way per se, but others could be as well. But even then, the excessive demand provision applies to them. But there's no consideration as to the benefits with respect to that. So the process in terms of this approach is fundamentally flawed with respect to that. So I would ask the minister to take a clear look at that, because the approach that has been undertaken does not take into evaluation of the benefit side. And so the other issue that I would bring forward to the minister's attention is that in the application of the process from the government's official, it stated that housing, for example, is not considered as a cost. Is not considered as a cost in determining whether or not a person is part of, that contributes to part of the excessive demand. I actually have a letter here from a lawyer who brought this up in an actual case, and in their letter from the officials, it lists supportive housing as a issue to be considered as excessive demand, and that was one of the reasons why they were being rejected. So the application of the law is flawed. So I will ask the minister this question: would you agree that the analysis in terms of how the government came up with the numbers to determine what is deemed to be excessive demand is flawed, and that also the application of that policy is also flawed?
First of all, before I answer the question, I would just reassure the honourable member that this is not an exercise in rhetoric on my part. I'm very cognizant of the fairness issues that are raised by this policy, and which is why I'm very committed to not only the review but also receiving recommendations from this committee. Just reading the provision, the regulation talks about excessive demand is, and when you go to subsection B, it talks about the definition of social services. Social services means any social services such as home care, specialized residence, and residential services. So that addresses your issue around housing.
Well, Minister, in the formulation, maybe the minister will answer this question. Would you agree that the formula in which the government has come forward with on determining excessive demand is flawed?
I can't comment on that. What I can say to you is that the whole policy is being reviewed, and part of your recommendations, if you feel strongly that the process in its application is flawed, and you bring forward options to address that flaw, then I'm open to that.
Well, my question to you, Minister,
I'm afraid that's the end of your time. I just want to clarify to the committee what I said about the request for information. This committee does have a reputation for being, a good reputation for being one of the most demanding with respect to officials' questions, and that's very appropriate. With respect to this study, the department has responded with 26 answers to questions raised by committee members. I believe a couple may still be in translation. A couple were combined. However, there are no outstanding questions with respect to our study with respect to medical inadmissibility. So we thank the officials. We know that places a burden on you. With respect to the motion that Ms. Rempel referred to, that had to do with our study on the irregular border crossings, and there remains one outstanding request. That request deals with the request of the provinces and territories IRCC. There's requests outstanding from other departments, but to IRCC, one request getting information on costs from the provinces engaged in this, and we are awaiting, the department is awaiting information from the provinces and territories, or really just the provinces on that one. So there is an outstanding IRCC request on the other study. However, we do have requests from other departments who may not be as used to our requests as IRCC is. So we thank you for your diligence in getting those answers to us. I do want to mention as well, because we have asked about the provinces and territories, we have also, as a committee, asked the provinces and territories to weigh into our study on this, and we approached the 13 governments. All of them declined to appear before our committee. They were then asked if they'd like to submit written submissions. 2 have responded, Nunavut and Saskatchewan, and Saskatchewan is in translation now. Nunavut was a letter. It was a very brief letter. But that's where we're at with those requests and our due diligence attempting to get the province's opinion on that. So I think I've clarified that when I said most of the stuff is in. All of it's in with respect to this study, and we have one thing we're awaiting on the irregular border crossings, and that gives me a chance again to thank Ms. Edlin particularly, but also all the officials for your work on behalf of the Parliament of Canada in your accountability to us and being effective in doing that. So thank you. Mr. Sarai and Mr. Whalen, I believe, are next.
Thank you very much, Mr. Chair, and thanks, Mr. Sarai, for providing me the first 3.5 minutes to provide some comments and ask some questions. In terms of the very diligent work that Ms. Rempel and Ms. Kwan have done, they've accurately summarized the situation before the committee, as you would have seen in the blues. The issue isn't whether or not we should change 38(1)(c). We should. The question is really whether or not we should eliminate it entirely, or if we do retain it in some fashion, how can we retain it in a way that will preserve the human rights and dignity of applicants and mesh with Canadian values. And I have to say that at this point, I side with Ms. Kwan. On the basis of the evidence before me thus far, I do not see how in a free and democratic society we can justify any threshold under the Oakes test that would reflect the importance of Section 15 of the Charter, and any limitation in this particular context, based on the evidence before us, just seems to be out of line with our values. I highlight the fact that about 170,000 applicants per year would be affected by the provision, and amongst those, only about 1,000 are rejected. So we are cleansing that 170,000 of 1,000 people who are too sick or disabled to come into the country. Right off the bat, just making that statement, you realize how egregious this is. When we balance the economic benefit of those 170,000 people and the social benefit of those 170,000 people to the nation as a large, it greatly dwarfs the cost of the health care to the 1,000. And I would further note that even if we do look at this $135 million a year, and whatever number that might be, some people have said it's less, some of the testimony has been that it underestimates, but regardless, the amount of that number is de minimis when compared to the overall national spending on those types of services, and so it's impossible to see how allowing these 1,000 applicants into our country and cleansing our own souls would put any real jeopardy to the social services or the healthcare system. So I ask, my question would be, if the committee recommends that we just simply eliminate Section 38(1)(c), and you accept that, how can we be sure that the application of Sections 38(1)(a) and (b) don't do through the back door, don't provide discrimination on the basis of disability or health status through the back door, what the committee and you have explicitly asked the government to do through the front door? So I just want to see if there's any mechanisms within the Act that we should also be looking at, that if we want to eliminate 38(1)(c), that there might still be some discrimination existing in 38(1)(a) and (b) that we haven't canvassed, because nobody has asked for those to be eliminated, and yet I am concerned that they could allow government and the department to continue to discriminate against the disabled or the infirmed. Thank you.
I don't think A and B are connected to C. I think A and B, I mean, B is self-explanatory, but A, I believe, is issues around, an example would be people who have tuberculosis, who who are screened to make sure that they don't spread TB in Canada. So that's the public health example. I don't think it's the same as C. I think what we're looking at is 38(1)(c), and there we have a number of options. One is to double or triple the current threshold where it kicks in. Right now, it is $33,275. We could double that or triple that. The second one is we could strengthen or clarify wait list consideration by adding a schedule of services with wait lists by jurisdiction. The other one is the definition of services. We could remove special education and related services from consideration in 38C. We could exempt certain immigration groups, consider exempting additional immigration categories in legislation, temporary residents, economic class, principal applicants, and dependents. We could stay with the status quo, or we could completely eliminate it. So all those things are under consideration, but we have to hear from you and others on how to proceed with this.
Thank you, Minister. And I must say, at this point in time, I do not see how raising the threshold and excluding fewer people changes the fact that excluding anyone is prima facie discriminatory and violates Canadian values. Mr. Sarai?
Thank you, Minister. Thank you, Mr. Whalen. We heard testimony earlier in terms of how much it costs. The average is about $7,000 is the threshold for medical inadmissibility, being the average that an average Canadian expends in a year on medical expenses. When we actually take $170,000, and I think the number Mr. Whalen and I have using are when you take out refugees and you take out family class that are exempt already, it's approximately $170,000. It's only 900 people that are, and that 900 people, if they were admitted, would actually comprise the average of 7,000. So we're not pushing the average higher because as Canadians, we have the same diseases, same illnesses, same disabilities. So putting all that into consideration, our expenses are $7,000. So in fact, right now, we're actually probably lowering the average artificially by excluding them. And initially, I would say when I came to this, I thought it was a good policy, maybe because it's a big burden on Canadians and perhaps, but then I look back and I don't want to equate it to this, but it's no different than the slave trade where only the selective, the strongest, and the most able-bodied were brought from Africa. Not that that whole policy is good at all, but I'm saying it is akin to discriminating when we're picking only healthy, fully functioning, no intellectual disabilities, no physical disabilities. So I think as a country, when we look at the cost, even if it was double the average per person, we're looking at such a small number, 6.3 million being 7,000 times 900. You double that even and it's still 12 or 13 million. You triple that and it's still an inconsequential number compared to the overall immigration. So I'd like to just express my opinion on that, and I wanted to share that with you, Minister. My second is, if we're going to if the committee has heard witnesses that applied for permanent residency status in Canada, and many have been refused based on the medical inadmissibility, what's the IRCC doing to mitigate those challenges kind of related to medical inadmissibility faced by individuals who are already in Canada and who cannot get permanent residence because of one family member? And what we have heard so far is that those that have applied with a plan of mitigation, very, very few have been accepted. We've also heard from some evidence that the expenses used to calculate their inadmissibility are not the ones that are actually used. For example, they're using branded drugs when in fact our medical
if you would like the minister to answer, you have to wrap up and give him a chance. You're getting over time.
I'll let Ms. Edlin take that.
So I already spoke about the cases that end up getting approved on humanitarian compassionate grounds. So the 91% of folks who have asked for that after a finding of excessive demand were successful in being granted visas. On the side of the mitigations plan, you'll see in the answer to the undertakings that over the period of 2013 to 2016, there were just over 700 mitigation plans that were successful. So again, those are two different ways in which some of this is mitigated. So the actual excessive demand finding is not the end of the story all the time. I would also say in terms of the costing using branded drugs as opposed to generics, What we do is that we actually look at the advice from the treating physician and what that treating physician has prescribed for the individual. And if it's a branded drug that's more expensive, like in the context of HIV, that's what we cost against. We don't want to make a supposition that the person should be on a different drug treatment plan that's a generic that may not work as well for them.
Thank you.
So if the specialist says generic is fine, then we recost.
If I could just clarify from the analyst, which specialist?
So this is the treating physician of the individual.
That is approved by RCC.
That is approved by RCC.
No, so our medical officers aren't treating anyone.
No.
It's the material that's provided to us in terms of here's what the individual currently has as medications that they're taking for their conditions, for example, for HIV or renal failure or whatever. And then we cost against those medications as they have already been prescribed and being used by the individual.
But it is an IRCC-approved panel physician.
No.
No? Okay.
Not
Just-
necessarily. Like these are specialists that the applicant has already seen in the country of origin. So the recommendation comes from them, and they're not IRCC panel physicians. They could be specialists.
Could be it.
Yeah.
All right. Thank you. And I like it when the analysts ask questions like that because it will help our report. So thank you. Mr. McGuire, you're going to get a little extra bonus. You get 6 minutes.
So I just want to get right into it. Has the province or territory, Mr. Minister, explicitly, has any province or territory explicitly asked for the excessive demand clause to be eliminated?
No. My discussions with the provinces and territories, my first question to them was, do you believe that we should move ahead in terms of bringing this policy up to speed to where Canadians are in terms of our vision of being more inclusive as a society? And the overwhelming response there was, yes, we should move this policy into the 21st century in line with our values.
Okay, no, thank you. I appreciate that.
There was no particular explicit feeling from one province or territory that said, let's get rid of it.
Okay, and have you met with any of the provincial or territorial health ministers?
No, I met with the ministers responsible for immigration, but before that meeting, we had a teleconference where we discussed this issue, and then they went back and met, consulted with their respective health and education ministers and social services ministers, because this impacts those ministers as well.
Yeah, okay,
and their
but
feedback reflected those consultations.
Yeah. Is there any empirical evidence that suggests that the excessive demand clause is affecting our ability to attract high-skilled immigrants?
I don't understand the question. Could you clarify?
Well, I just wondered if there's any, if in the discussions you've had, is there any evidence that the excessive demand clause is affecting or prohibiting anyone, or it's just simply affecting the ability of us to attract high-skilled immigrants?
Not to my knowledge, no.
No. There's some cases, I guess, in some communities that have rallied behind a particular individual or family.
Yes.
To stay in Canada, but they were determined to have an excessive demand on their healthcare system. Mm-hmm. Is there any way that we can ensure that Canada is still screening for excessive demand individuals, but to allow greater flexibility for individuals or families who have deemed to fill a high-skilled labor shortage?
That could be one of the ways in which we can change the evaluation mechanism with respect to this policy, and it could be one of the ways to address that particular example that you raised, and so my answer to that would be we would examine that if that's something that stakeholders feel we should take into consideration.
Thank you. Yeah. It's also been suggested that we eliminate immigration medical examinations due to their cost. These are the examinations that determine, as you pointed out, danger to public health, danger to public safety, and excessive demand. Mm-hmm. Do you believe that Canada should not be conducting immigration medical examinations on potential immigrants to screen for such things as tuberculosis, dementia, and schizophrenia before they immigrate to Canada?
I don't believe that we should eliminate medical examinations related to immigration.
And if they were eliminated, have you done any, in the discussions, have you done any analysis of the future impacts which would include sort of the future numbers of applications and the costs.
I don't believe that we should eliminate medical examinations related to immigration. That's not the policy of our government, and therefore we haven't done that analysis because we're not moving in that direction.
Okay, but
in the direction of eliminating medical examinations, because they do raise.
But if S38,
they do screen for public health.
If S38 itself was eliminated,
Sorry?
if you looked, but if S38 was eliminated.
Well, we're talking about even if we move towards that direction, it's 38C, not 38A, B, and C.
Right, 38C.
So public health is still an issue, right? So we would still screen for.
But if you eliminate it, have you looked at whether there'll be more applicants come into Canada with disabilities in the future, and what the cost might be?
We haven't looked at the immigration patterns resulting from the elimination of the policy. In terms of the cost question, I'll ask Ms. Edlund to respond to that.
Well,
In terms of the
Michael?
averages,
And as we've indicated previously, we've provided an estimate of the dollar cost related to the specific individuals that have undergone the assessment for a given set of representative decisions. It's difficult to estimate, and as I understand it from what the committee members have described, you've heard both sides that that estimate may be too high or too low. Certainly at the level of officials, when we were in discussion with the provincial and territorial departments responsible for immigration, in a number of cases, the provincial officials raised the issue that we were not considering the potential of a deterrence effect. And that was because we were unable to assess that on an evidence-based approach. It's hard to tell, therefore, whether or not elimination of the 38 in its entirety or just 38C would have a significant impact.
Sorry, I've got a couple more questions.
And 13 seconds.
When a potential immigrant is deemed to have an excessive demand on the healthcare system, there's a number of various ways that you can appeal, and such as putting forward a mitigation plan. Provincial territorial authority could say that they fully accept the financial responsibilities, and you as the minister have the ability to waive that excessive demand clause on humanitarian grounds. And I'm just wondering if these, Mr. Minister, are these avenues still good enough to ensure that Canada is able to attract the highly skilled immigrants that we are after?
Very briefly.
I mean, I've already answered the question with respect to whether this affects our ability to attract highly skilled immigrants. I don't think, in my opinion, I don't think that's the issue at hand here. I think the issue is one of fairness and an incompatibility with our values.
The appeals, the three mechanisms of appeal that I suggested are valid and good enough.
Well, you're saying good enough to address...
To continue with the present program, and it gives you the right to have the ability to waive that excessive demand clause.
I'm afraid I can't give you a chance to answer. Sorry.
Thank you, Chair, and thanks, Minister, for coming today. And thanks for undertaking the fundamental review of the excessive demand provision, because we have heard in the testimonies that how painful and many families have to go through a lot of emotional stress. I'm one of them. Many years ago, my mother-in-law's case of immigration was rejected because of medical inadmissibility. We have heard testimonies about the effort and the resources that are put into the mitigation plans when an applicant receives a letter warning they're facing a finding of medical inadmissibility. Immigration lawyer Michael Batista said they evaporate after a permanent resident becomes a permanent resident. He added his firm charges $4,000 to $5,000 to prepare a mitigation plan, as it's labor-intensive, and those fees don't include extras like expert medical opinions. He added the system does seem to be economically biased towards those who can afford the legal fees to fight the determinations. Roy Haynes of Carleton University said, "This creates a two-tier system, those who can afford legal help and to mitigate their cost, and those who cannot. And the latter or more often find the door to Canada is closed." Minister, can you please tell us what happens to these mitigation plans after they are accepted? I'm not suggesting enforcement of these plans, bearing outright fraud. We heard that systemic tracking would be expensive and a bureaucratic nightmare. It does lead to the question, though, what purpose do these mitigation plans serve? Are they achieving that purpose, and are they creating a two-tier entry into Canada?
So before I let Ms. Edlund answer the detail of the question, I'll say that the issues you raise around fairness, around accessibility to Canadian society base that are raised by this policy is precisely why we're studying it. It's precisely why it has raised issues around fairness. It is why we launched the review, and it's why we thank the committee for studying the issue, because we think that that will inform our approach moving forward to make it a fairer issue. And as some members have indicated, they would even prefer it to be eliminated completely, and that is certainly one of the options.
The concept of mitigation plans came into play after the Supreme Court of Canada decision in 2005 called Hillwitz and de Jong, where the two individual applicants wanted to present evidence of how they could mitigate the costs of special education in one example. And the Supreme Court of Canada said, we as a department need to listen to what those plans are and understand them and evaluate them. And so it was after that that we put the mitigation plan concept into effect in response to the Supreme Court's decision.
Are they achieving their purpose, do you think?
It's really hard to tell if they're achieving their purpose because we don't track or monitor them after the fact. And as I said, the last time I was here for this, before this committee with this study, we don't have any enforcement mechanisms possible to see whether or not someone's actually followed the plan that they put forward. So we don't have line of sight on that at all.
Thank you. Minister, we have heard examples of cases of medical admissibility that came to your office for appeal on HNC grounds. We heard of cases such as that of a caregiver, Mercedes Benitez, who have received a waiver through this route. We also heard that there are many cases that don't receive the media attention that cases like Mercedes' case did, and that HCR appeals are an answer to a bad law. I would like to ask, when you look for when you receive an HNC medical inadmissibility appeal, and if you are overturning 90% of those decisions, like, does that speak to deeper issue with the medical inadmissibility process?
First of all, on the case that you referred to, it was an officer who made the humanitarian and compassionate grounds decision. It wasn't me. It was an immigration officer who made the decision. With respect to the cases that receive media attention and the ones that don't, it's precisely why the fairness issues that are raised by these cases is why we are where we are now. But I want to remind again the committee that this policy has been in place for more than 40 years. No government has changed it. We are moving ahead, and we believe that now is the time to do so. And it's precisely because of the heart-wrenching cases that have come up that have been concerning to Canadians and to members of Parliament, including yourself. And it is why we believe it's time to move forward on this policy, to make it, to bring it in line with our values.
Thank you, Minister. We have 2 minutes left in the meeting, and with the committee's agreement, I'd like to give it to the analysts to ask the officials point of clarification. Is that okay with the committee? Madalena.
So just regarding the drugs that are recommended on a prescription from another country, not all countries have the same generic drugs, or the prices are really different. So we were wondering if a specialist recommends that a person takes drug A, is there a possibility that, generic drugs are also specified in that prescription, so when they do come to Canada, and if they have access to the generic drugs, they're not penalized.
Thank you. No, the drugs that are recommended are by this treating specialists, which are different than panel physicians, or different than IRCC medical officers. And the drugs are different in different countries. So what we look at when we do the costing is their equivalent medication in Canada.
Therapeutic substitution.
Therapeutic substitution, and also the publicly funded portion of that, because the whole cost may not be subsidized. So we look at the provincial formularies and look at what is going to be subsidized by the provincial government, and the cost is based on that.
Thank you.
Thank you, Chair. I just want to make note of this. We started a committee meeting 5 minutes late, and then, of course, in the middle, Mr. Chair, you interjected, and I believe your comments took about 4 minutes and a little bit. And now 2 minutes with the analyst, which I don't oppose. But that said, what that meant was that it robbed me of another round in terms of, because I believe the next round would be 5 minutes with the Liberal member side, and I would get another round.
That's fine. You can challenge me. Actually, wouldn't have limited you because we still had 5 more minutes from the Conservatives and 5 more minutes from the Liberals. So we wouldn't have gotten there. But I accept that. My hope is that my main goal is that the committee as a whole gets the information it needs from the officials who are here. So that's why I felt it was important to clarify decisions that were done. We've come to the end of the meeting, so it's time to adjourn.
you.